So good afternoon, everyone. Waiting a minute for Zoom to self-populate, and we will begin our presentation shortly. People are creeping in. It's great to see so many people joining. So while we wait, again, I wanted to say how pleased we are that so many of you are in attendance today, including many friends and colleagues from all over the world, and that we can be here together, albeit virtually, but still together. So without further ado, I think I will start. Good afternoon and welcome to the 5th webinar in our Trademark in Canada series. I'm Ekaterina Tsimberis, a partner in our trademarks practice group of Smart and Biggar, and together with my colleague Olivier Jean-Lévesque, here with me today, we will be talking about geographical indications, what they are, how to protect them, and what brand owners need to be mindful of. So a few housekeeping matters. Our presentation will last about 35, I would say, to 40 minutes, actually, with additional 20 minutes for questions and answers. We want the presentation to be as interactive, open, and relevant to your practices as possible. So we're happy to receive your questions, which we will address at the end of the presentation in the 20-minute Q&A section. In terms of asking questions, please use the question and answer panel at the bottom of your screen. It should say Q&A. Do not type your questions in chat, because unfortunately we won't be able to read them. We'll have too many things going, just reading your question and answers at the end. But we will try to answer as many questions as possible during the present. And if ever there are any at the end that we haven't had a chance to deal with, we will endeavor to get back to you by email separately after the webinar. And finally, I just wanted to say today's webinar will be recorded, and we will be sending along by email the PowerPoint presentation and the recording for anybody that wants to see it afterwards. So more people are piling in, but without further ado, I think we'll start. Most of you in attendance today are familiar with our firm, and we have a strong working relationship with many of you attending today. Our firm has expertise in all areas of intellectual property, as most of you know. With respect to our GI work, we help protect and enforce GIs, geographical indications, from all over the world, and help counsel our clients who are brand owners and who may be faced with trademark questions or issues related to GIs. We have considerable experience, Olivier and I, with the protection and enforcement of trademarks and GIs, both before the Trademarks Opposition Board and before the courts of Canada, federal court more particularly, and thought we would share some of our experience with you today. So before we get into the objectives of this presentation, which are twofold, it is important to make sure we're all on the same page regarding what is a GI, what is a geographical indication in Canada. So a good way to explain, I always find, is just an example. That's the way my brain works. And one well-known example in my view is champagne. So what is a GI? Contrary to a trademark, we all know, is a source identifier that points to one source. The entity is the source of the product. A GI also points to one source, but the source that it's pointing to is the terroir, or the location. The territory. So here on the slide, we've put what is a geographical indication. It's a specific territory, like Champagne in France, where unique wine, spirit, agricultural product, food is produced. Those are the 4 categories of things that can be protected by GI in Canada. And that points to a quality, reputation, or other characteristic of which is attributable to its geographical origin. So we'll get into more of that later on in the presentation, but it's the notion of a shared goodwill. That's what, a shared goodwill. And that's what's important to remember. So it was important for us today that this presentation consider GIs both from the point of view of GI owners and from the point of view of brand owners, given you, our audience today, reflect those two audiences. So in this presentation, we will try to answer 2 questions for you. How can GI owners best protect their geographical indications in Canada, including how can they enforce them? And what should brand owners know to avoid misusing others' GIs? And I'll turn now to Olivier.
Thank you. Geographical indications can be protected in Canada through several provincial and federal laws in one way or another. This presentation is going to focus on the protection that's provided by the Trademarks Act, where the vast majority of both foreign and local GIs are protected in Canada. As we will see, GIs can either be protected in Canada as unregistered, or what we might call common law GIs, registered GIs, and certification marks. So I'm sure a lot of you may know, just like a trademark owner can generate rights in a trademark solely by using it, the law in Canada recognizes geographical indications, even if they're not registered. And Ekaterina will discuss what that entails exactly in a few minutes. So your indication must, of course, meet the definition of what a GI is, what Ekaterina explained. So an indication that identifies a wine, a spirit, a food product, whose quality characteristic are attributable to its geographical location. And the typical example of what a common law GI is would be, for example, an appellation d'origine contrôlée, protected in France, that's well known to Canadians, but that's just not registered in Canada. For example, well before cognac was registered in Canada, well before it was protected formally in Canada, consumers knew it referred to a specific type of spirit, a specific type of brandy from a specific region of France. So it was a geographical indication, even if it was not a registered geographical indication. But now the question becomes, how do you enforce a common law GI? Well, first, by relying on the prohibition regarding descriptive and misdescriptive trademarks. So descriptive terms, including geographical indications, cannot be monopolized in Canada. By definition, a geographical indication is descriptive of a place of origin. Champagne is descriptive of the region of Champagne and of a character of a quality. So if a third party tries to register a term that is confusing with your GI, it's also likely also going to be descriptive. Owners of common law GIs can rely on this in the context of opposition proceedings, so to oppose the registration of a trademark, or the context of an invalidity attack, for example, so to invalidate a trademark registration. Also, and perhaps most importantly, GI owners can rely on the law of passing off or unfair competition, which is essentially what we used to protect and enforce GIs years ago before the Trademarks Act was amended to specifically protect geographical indications. So here again, it's a prohibition that no one can pass off goods or services as and for those ordered or requested. So you can't pass off a Canadian brandy as real cognac. You can't make use of a description that's false or misleading. If your menu lists cognac, but you serve Canadian brandy to your consumers, it's false and misleading and contrary to the law of passing off unfair competition. So this is extremely interesting for GI owners, but the main downside is you need to establish goodwill. So you need to establish that your GI is well known in the relevant area. You need to establish misrepresentation. And of course, this is not easy to do. It's sometimes very costly. So just like with trademarks, it's always best to register your rights. Both local and foreign GIs can be protected in Canada, or registered. There are two ways to do this. First, either by submitting a request, an application for the registration of a GI, or through international treaties. The CETA, the Comprehensive Economic and Trade Agreement between Canada and Europe, which was signed a few years ago, is a good example. Essentially, all GIs for food products and agricultural products that are currently on the list of protected GIs in Canada were protected through the CETA. But obviously, unless you have great ties with sustainability, the easiest way to get a registered GI, protected GI, is by filing an application or request, just like you would do for a trademark. And Ekaterina is going to explain a little bit what that entails.
Just unmuting my screen, sorry. Yeah, so thank you, Olivier. So the request is made through the Trademarks and Industrial Designs branch at the the Canadian Trademark Intellectual Property Office, with a relatively straightforward form in which we indicate, what is the GI? The associated goods. Is it a wine? Is it a spirit? Is it an agricultural product, or is it a food? The territory that it covers, and the applicable law protecting this GI outside of Canada, if applicable. A description of the quality, reputation, or other characteristic of the wine, spirit, agricultural product, or food that is essentially attributed to its geographical origin, and the name of the responsible authority. So we've provided an example of Bordeaux here, and you'll see everything that's covered there and how it's been entered on the register. So basically, the process is quite similar to a trademark application in a way. You submit your request. It's called a request, but it's like an application. It's considered by the Industrial Design Office, Trademarks and Industrial Designs branch. They usually write you back if they have any questions or an office action or a request for additional information. They can either write you back to accept or refuse. Hopefully it's accepted and it's published for opposition, or I would say objection proceedings, objection purposes, because in the Trademarks Act, they talk about objections from third parties. And if no objection, well, then it gets entered on the list. So what we've done is we've provided you with the link down here of where you could find this list of geographical indications. It writes a list of geographical indications, but it is the list of protected geographical indications. And basically, as of June 2021, this list of protected GIs contained more than, just for wines, I'm just talking wines, we didn't do the analysis for the other ones, but just for wines, 864 local and foreign wine GIs that were entered on the list between 1998, when this list of protected GIs was created in the Trademarks Act and was created, and today. So you can find them in terms of alphabetical, but also, which is interesting if you're searching, but you can also find them in terms of countries. So if you want to figure out which countries have what, you can figure that out. So what is the benefit of having a protected GI, spending the money to get this protection, this added protection? Well, the first added benefit of protected GI is that once it's registered on the list, there are no renewals, right? No added payments, no trademark portfolios to manage. Second benefit is less opposition proceedings. Why? Because by having a protected GI, the Trademarks Office, in the examination of trademark applications filed by brand owners, would do some of the work for you if you're a GI owner by citing a protected GI to an applicant. And from experience, just to let you know, the Trademark Office cites just those protected GIs that are identical, and for those wares that are identical to the wares covered for the trade protected GI. So you have the here on the slide, the potential objection and the prohibition to register a trademark. So that's the basis of that foundation and the benefit of having a protected GI. The next one is that it provides you with, and if you're the GI owner, with an additional scope of protection. So it's a real prohibition to use and adopt a protected GI, and use is quite large in the sense of the definition, right? It's quite large. So it's prohibited to use and adopt a protected GI or its translation, and I'll come back to that after, in association with the wine, spirit, agricultural product, or food not originating in the territory. So for example, I wanted to give you an example. In the US, the Barefoot Bubbly California champagne on the left, the pink bottle, the pink liquid, the pink liquid inside, is sold in Walmarts in the US, while across the border in Canada, there's no reference to champagne on the label. It actually specifically writes, California sparkling wine on the bottle on the right. So this prohibition is very helpful. And it is real, and it does cause for people to be careful with regards to the difference between different jurisdictions in the terms of protection of certain GIs. So lastly, the last benefit that we wanted to bring to everyone's attention is an important one. So having a protected GI allows a GI owners access to the border security measures in Canada. Because of the prohibition on the import and export of goods bearing a protected GI, it allows customs officers to detain suspected counterfeit goods at the border. So GI owners can record their rights in a protected GI through Canada Border Services Agency's RFA program. And if there's any questions, just let us know. Write to us, and we'd be happy to help you as we've helped other clients register and file requests for assistance. I'm turning to you now, Olivier.
Thank you. So lastly, something that we sometimes forget is that GIs can also be protected in Canada as certification marks. So I'm sure when you think of certification marks, you think of the fair trade logo on chocolate, you think of the certified organic sign at the grocery store. But by definition, a certification mark is something that can be used to distinguish any product that meets certain predefined standards, including in terms of geographical origin and quality, which is essentially what a GI is. A good example of that is Chianti Classico, which of course is wine from central Tuscany, and which, as you can see, is protected both as a protected geographical indication and as a registered certification mark. And the benefit of that is that it quite drastically increases your scope of protection, giving you several additional causes of action against unauthorized users. So yes, the provisions that pertain specifically to certification marks, so the prohibition to register a confusing trademark, unauthorized use, prohibition to use a certification mark if it's not licensed. But also, and perhaps most importantly, it allows you to sue for depreciation of goodwill. So Section 22 of the Trademarks Act. What does that mean? In practice, is that it makes it much easier for you to prevent the use of your GI in association with a totally unrelated product. So, for example, to prevent champagne from being used on a t-shirt with tasteless comments on it. So for clarity, I'm not saying that if you didn't have, or if you don't have a certification mark, you couldn't sue for something like that. But it would make it a little bit more difficult. So the cumulative protection of a registered certification mark and a protected geographical indication is really a plus. So now that we've discussed how to protect a geographical indication in Canada, we're going to turn to the second part of the presentation. And I think the fun part of the presentation, in my opinion, where we will give a few tips, or try to give a few tips on how to avoid misusing others' GIs by reviewing a few case studies that Ekaterina and I were involved in. The first case study, and I won't spend too much time on it, is Pré-Provence. So this was a while ago. An American company called European Soap filed a trademark applications for Pré de Provence in association with cosmetics, including soaps, foam baths, shampoos, conditioners, and most importantly, oils and body oils. Pré Provence probably directly translates to prairies of Provence, so it's quite descriptive trademark. And importantly, Provence in the south of France is well known for its essential oils, including its lavender oils, which is protected by a geographical indication, where we're seeing it on the screen, Huile essentielle de lavande de Provence. And so this was brought to the attention of our client, and eventually we learned that the applicant's product do come from the region of Provence, but it was not apparent from the trademark application. The application was filed in the name of European Soap, a company from Seattle. And so we eventually launched an opposition, and the applicant amended its application to delete bath oils and body oils. Here, the reason why our client took action is not just because the trademark itself was descriptive, but also because the products associated with the trademark, essential oils, were something that Provence is known for. So it's important to keep in mind that a trademark registration is a monopoly. It's an exclusive use, right? So a descriptive trademark registration may unduly deprive others, including actual producers, from describing their own goods. And the takeaway is probably to be extra careful if your application is ambiguous. And what do I mean by that is, here the applicant was a US company. So even if the goods associated with the trademark did come from province, it was not apparent from the trademark register. And so people looking at the trademark register would not have known that they are imported goods from province. It would have sent the message to consumers that province can be used to describe goods regardless of geographical indications, including goods that come from Seattle, for example. And so that's probably the takeaway here. The second case study is a very interesting opposition proceeding, at least in my opinion, but I'm a geek for GIs, that Ekaterina and I were both involved in a few months ago. Rivoire-Jacquemin, a French company, filed an application for the word mark Juraman in association with cheese. And the word mark Juraman reflected the branding of the applicants as cheese, which, as you can see on the slide here, I don't know if you can see on the cheese, but you can definitely see on the photo, the second photo, featured what seemed to be a man carrying cheese, so perhaps a cheesemaker carrying the fruits of his labor. Of course, Jura, as I'm sure you all know, is a French region that is well known for its cheese, including the Bleu Jura, a creamy semi-sec blue vein cheese, the Comté, the Crémeux Jura, and other cheeses. Our client eventually opposed Rivoire-Jacquemin's application, and the problem here was, unfortunately, was a catch-22 for the applicant. First, goods were not limited geographically, so the trademark Juraman could have been associated with cheese that does not come from Jura, or cheese made by people that do not come from Jura, which of course would not have been acceptable to our clients, people in Jura. It would have sent a message, just like for Pré de Provence, that Jura can be used to describe cheese, regardless of geographical location, regardless of where it comes from. But then also, if the goods did come from Jura, a trademark registration for Juraman would have given this cheesemaker too big of a monopoly. It would have unduly deprived people from Jura to describe their goods in a certain way. To say on their products, on their packaging, that their cheese is made by a man from Jura, at least in a certain way. So eventually, the Trademark Opposition Board accepted that the mark as a whole, consisting of the terms Jura on one hand and man on the second, designates men and individuals from the region of Jura. As I mentioned, the wording of the application was not limited geographically or to the identity of the persons who produced the cheese covered by the application. So the application covered both cheese that produced by men in Jura and cheese not produced by men in Jura. So the trademark was considered clearly descriptive or deceptively misdescriptive of the persons who produced the goods covered by the application, and thus non-registrable. The takeaway here, it's probably that the fact that your TM, your trademark is in part a geographical indication, registered or not, can be a good indicator of whether there's a risk that someone will take offense to your use or registration of a trademark. And it's important to keep in mind that I talked a little bit earlier about the prohibition regarding descriptive and misdescriptive trademarks. And it's important to keep in mind that it's not just trademark examiners, the registrar, that wants to prohibit the registration of descriptive and misdescriptive trademarks. It's also people who may be deprived of a way to describe their own goods. It's people that don't want producers from elsewhere to benefit from the shared goodwill, as my colleague mentioned, that they have built. And what I mean by that is Jura, in association with cheese, is an indicator of quality, of origin, and of quality. Producers from Jura, which have been making cheese for decades, for probably centuries, will not want someone from Russia to be able to say that their cheese is made by a Jura man, and that was the problem here. And I'm going to let my colleague discuss the third case study.
So I will unmute myself. So the third case study is relating to federal court action and oppositions that happened because of a restaurant located in Old Montreal called La Champagnerie. It was a restaurant and a bar that served not only champagne, but also other sparkling wines. The restaurant was decorated with quite a bit of champagne paraphernalia that I've shared with you on the right side of the screen. So La Champagnerie also filed trademark applications for the word mark, La Champagnerie, and also the design mark on the right-hand side of the screen. So for those that aren't familiar with or knowledgeable in French, the meaning in our view of La Champagnerie in French is a place where champagne is sold, very similar to a fruiterie, is a store where fruits are sold. And in addition to the restaurant that was pictured here in the services, what the defendant or the applicant had done was it also launched a sparkling wine from Spain under the trademark Cuvée La Champagnerie. You see it on the receipt here. And you'll see the bottle here does mention Cava Torello Brut, but above it has the trademark La Champagnerie as well. And so the wine was actually a Spanish one, as I said, of the Cava appellation, and as such didn't conform to the Champagne protected GI. And, according to the Trademarks Act, that would be a prohibition. We already covered that. So their use in association with wines was problematic to our client, obviously, but it was also problematic, the use of their trademark with regards to the bar and restaurant services. So our challenge was twofold. Our challenge was to prevent the use of the Champagnerie, a trademark not identical with the Champagne protected GI, in association with a Cava labeled wine. But the second challenge, which was even more difficult in my view, was to prevent the use of La Champagnerie with restaurant and bar services. So the Comité Champagne, the CIVC, but we call it the Comité Champagne, INAO, which is a body in France that takes care of all enforcing the rights of all French appellations of origin, and the Coopérative Générale des Vignerons de la Champagne Délimité, that's the Champagne Cooperative Producers Cooperative. So they all decided to file a lawsuit before the Federal Court of Canada and to also file oppositions. And basically, what we see here is what we crafted, the strategy that we developed to make it so that what the activities of the bar and restaurant services that the defendant was doing would be contrary to section 11.14 of the Trademarks Act, which talks about, and you see here, we've sought a declaration. The defendant's advertising and performance in Canada of bar and restaurant services in association with the trademark La Champagnerie, which involve the sale and services of wine that do not conform to the Champagne protected geographical indications. And many of them were not. They sold some champagne wine, but many were not champagne. Constituted an adoption of the protected GI in respect of a wine not originating in the territory. So that was how we crafted our lawsuit. This file did not go all the way to trial. There was a confidential settlement between the parties that came well in advance of trial. And here, what the settlement, what I can is just share with you is what's on the record of the Trademarks Office and on the federal court. So the trademark applications were abandoned in Canada and worldwide of the applicant. The name of the restaurant was changed to Maison Saint-Paul, as you can tell from the picture, and the federal court issued a judgment on consent on September 18th. So of course, the judgment was rendered by the federal court. I don't remember the judge anymore, I apologize on that, but on consent of the parties provided for the following four, and it's not exactly what is in, because it's a big long document, but I tried to summarize it as best I could, the essence of each of the three declarations that the parties, that the court rendered. so had infringed the protected GI was the first declaration. The second was a declaration that the defendants had directed public attention to their bar, restaurant services, and wines to cause confusion between their services products and those of bars, restaurant producers of wines that offer services wines that conform to the Champagne protected GI. And who passed off their services as those who serve wine that conforms to the Champagne protected GI, similar to what my colleague Olivier said earlier. And obviously we wanted a permanent injunction restraining the defendants from using Champagne, except for those wines for which, obviously they're serving some Champagne wines. So I think the takeaways here are, and before I go into the takeaways, La Champagnerie probably thought, and I'm not in their head and I'm not their counsel, but just to share, is they thought they would be probably okay for a number of reasons, because their trademark was not identical to Champagne, because their services were not wines or sparkling wines, and they were offering just bar and restaurant services in association with Champagnerie. Also, they alleged in their statement of defense that their Champagneries in their vetted word does not make reference to Champagne, and that they were using Champagne merely descriptively and not as a trademark. And they were using it fairly, since they do in fact offer and sell some Champagne wines to their customers. But I think we need to be careful. And I think this is what the takeaways that we wanted to share with you. Their use and registration was deemed problematic by our clients and by the court, and not necessarily by the Trademarks Opposition Board, because we didn't get a decision there. But the takeaways, I think, are important that we've shared in this slide, and I won't read them to you, but be extra prudent. If your products or services, even if they're don't cover specifically wine, spirit, food, or an agroalimentary product for which there is a protected GI registered, if it's indirectly relating to it, you got to be careful. You got to use it carefully. And the other important fundamental that my colleague Olivier touched upon is the fact that when one uses a trademark or seeks to monopolize, in Canada, the word get exclusive rights to a trademark, that includes a protected GI, it would be to the detriment of others. And a GI, again, I'm just repeating myself, but sometimes, it helps, is it's of shared goodwill and it's important. So, so just one last thing here. So there we go. So I think the next case study is a further example of a similar situation, but with vastly different services. That involved airline services, travel services that are being offered by Sunwing, one of Canada's airlines, and travel services and vacation and hospitality services down south. This generated another federal court lawsuit. So Sunwing Airlines was offering, as you can see here, champagne flights to Paris, and where it advertised a complimentary glass of champagne during the flight. But consumers indicated and wrote many emails and letters to our client, saying that they were expecting a glass of champagne, but were not offered a glass of champagne. They were offered another sparkling wine. So they were let down. They wrote to our client saying, I don't understand how this could be possible in Canada. Sunwing Airlines then started using the expression champagne service in their all-inclusive vacation packages, and which included a flight, to some sun destinations, but offered again sparkling wine that was not champagne. Sunwing was of the view that champagne service could be used a bit generically as a slogan to simply refer to the high quality service of their product or their service. And so, unfortunately, for them, we weren't able to resolve it before filing a lawsuit. And again, we filed similar declarations that you see here on the left. And again, the formulation that we had come up with, it was the same strategy basically, and the same issue that we had with it, that they were using champagne in a way that infringed the plaintiff's protected GI, passed off their services of those who serve wine that conforms to the champagne protected GI, and we were seeking a permanent injunction to make them stop. And when I say we, it's not we, it's the Comité Champagne again, INAO, the same entity. and actually MHCS, which is Moët Chandon in France. It's a well-known champagne producer. And so this matter was also settled with a confidential settlement, and I won't get into anything other than just to share with you the federal court issued a judgment on consent, which rendered the permanent injunction. And as you can see here on the right, this is specifically what the court rendered, the judge rendered in this case. And so it's a permanent injunction was rendered enjoining the defendants by themselves or by everyone they're associated to from directly or indirectly using a trademark or otherwise the word champagne that is false in a material respect and likely to mislead the public as to the character, quality, composition, geographical origin, mode of manufacture, mode of production of products and services in association with wine or with any of their services that are listed here, except obviously when they serve a wine that benefits from the protected GI, champagne. So takeaways here is, and just to share with you, so to be fair to the other side, so Sunwing did mention in their statement of defense, Sunwing argued that champagne is known as a laudatory term in Canada for denoting excellence, superiority, and, as I said at the beginning, something that, according to them, just references the distinction and quality of their services. And they also argue that the terms and conditions publicly advertised that the defendant's champagne service includes a sparkling wine and not a champagne beverage. And so, again, I think we all in our industries, I know a lot of you come from, different industries, be wary of using a protected GI in any unauthorized manner without the permission of the owners. And it's just a good tip to, just to remember that. And don't assume that your use of a well-known protected GI and an expression that, you might deem to be generic or, laudatory will not be actionable, because in some cases it is. And the other point that I want to say just before I turn the slide again to my colleague Olivier is consider the impact on consumers. And with that, I will now switch my mic off.
Thank you, Katrina. So shortly around the same time we filed we settled the Sunwing file before the Sunwing case before the federal court. Consumer filed a class action on essentially the same basis, and the question was, did the defendants contravene the Quebec Consumer Protection Act by describing and promoting their services by using the word champagne but not serving champagne? So the case is ongoing, but there are already a few things that we can take away from this. First is that consumers are getting more and more knowledgeable on geographical locations and cannot be easily fooled. So regardless of the outcome of the class action, in my opinion, I think it's already a loss for Sunwing when you get a lawsuit from consumers. So be careful about how you trying to fool your consumers. And related to that, consider whether your marketing practices refer to a geographical indication directly or indirectly. And Ekaterina, if you can come back to slide 38, Sunwing was arguing that champagne was used to, as a laudatory term to denote excellence, to denote quality, but their marketing practices, their branding also, display glasses of what appeared to be champagne glasses. So be careful of, how you present your services, and yeah. So we'll see what's going to happen with the class action, but it's still ongoing.
So thank you, Olivier. So we're in the question and answer period. Let us just take a moment to open the question and answers. Maybe I'll ask the first question to Olivier. Olivier, there's a question on, are there a lot of Canadian GIs on the list of protected geographical indications?
There are a few. Ekaterina, if you can do something, just thank you. So there are a few. The vast majority of GIs that are protected in Canada that are on the list of protected geographical indications are foreign. So mostly from Europe, but also a few from from Asia, from South America. There are several Canadian ones as well. So Okanagan Valley is one I think of. I think Canadian rye whiskey, and Ontario ice wine, I think, is another one. But yeah, the vast majority of protected GIs in Canada come from Europe. I think, unfortunately, I think it's not as much in our DNA as it is for Europeans, but hopefully we'll see more and more Canadian GIs on the list of protected GIs in the years to come. And if you want to, Katrina, I can ask the second question if you want to answer it. You mentioned that there are other laws that protect GIs in Canada. Can you talk a little bit about that?
Yes, so a few provinces have their sorry guys, slight hiccup in the technology. So so there are a few provinces who have their own GI regimes. So for example, in Quebec, in the province where we live in Canada, we have the Act respecting reserved designations and added value claims, which protects, a number of reserved designations of origin, including Quebec ice wine, for example, and Neuville sweet corn, for example. And Ontario and BC also are very active, as we all know, in our regions that have similar regimes, also their own, legislations on that. And the problem is that each of these only provide a protection that's limited to their respective province. While some GIs, including Scotch and whiskey, are also protected in in other food and drug, I believe it is, Olivier, food and drug regulations. But of course, you can't really apply to have those, so when we enforce for cognac, for example, we do reference these other Food and Drug Act regulations. But of course, in our view, and I think that was the point of the conversation today, the Trademark Act is really the best protection there is, in our view, to get your GI registered. So hopefully that answers the question. Let's see what other questions are out there. So let me ask you another one here, Olivier. In your experience, I'm sorry, I'm reading it from the screen. In your experience, are distributors, retailers in Canada knowledgeable on GIs and respect GIs?
Good question. And Katrina,
yep.
That's going to be so I'm going to ask you to jump in, just correct me if you don't agree, but in my experience, and I think in our experience, yes. As some of you may know, in many provinces, government-owned retailers have essentially a monopoly over the sale of wine and alcoholic beverages in Canada. So that's the case here in Quebec, where we have the SAQ that essentially has a monopoly over the sale of wine and liquors. And these government retailers are very knowledgeable regarding GIs and respect GIs in general. So I don't think we would have an American champagne at the SAQ, for example. They just wouldn't sell it. The caveat for this is probably Alberta, which is almost fully privatized. So over there, we have a little bit more issues, a lot of infringing products that come from the US. Now that changed a little bit with the pandemic, with restaurants and bars that can have little shops and that can sell bottles of wine that they import. So it's going to be interesting to see if going forward, we may have a few issues with that. I'm going to ask you the next question.
Are you thinking about this one?
Yeah, good one. You didn't talk about changes to come in the law surrounding GIs in Canada. Should we expect any changes in the year to come?
So to our knowledge, there's nothing really in the works with regards to changing laws. That said, I think GI protection under the Trademarks Act was relatively recently expanded to food and agricultural products. So I think we're going to see more and more of these types of GIs protected in Canada. It's new, and I think quite a few clients and quite a few people out there would benefit from just knowing that now, food that they're producing, an agroalimentary product, even theoretically cannabis, can be protected through the types of, GI protection in Canada. So I think there's opportunities out there for stakeholders in the food and agricultural products to leverage. And I think like all intellectual property, it's what we create, right? It's what we as humans decide to create. And I think that's where I see things going, more and more of these GIs. So Olivier.
You know what? I have a follow-up before we jump to the next question. I have a personal follow-up regarding what you said. I think we discussed a few weeks ago that Russia decided unilaterally that from now on, the only type of sparkling wines that would be allowed to be called champagne in Russia are Russian champagnes. Can you talk a little bit about that?
Okay. Sorry, I was talking and I was muted. So it's an interesting question that you have, Olivier. I just want to make, before I answer it, I just want to make a clarification. So I think that some of us have seen that what happened in the US, in Russia with their, and because I'm part of this International Wine Law Association and on the board of the international one, so we exchange emails with practitioners all over the world. And something that a colleague of mine in Australia pointed out to all of us was that the new law that was signed by Vladimir Putin, the president of Russia, reserved exclusive use of the term champagne for domestic products. And so maybe what we're reading in the media is not completely, and I'm not very familiar with this whole thing, but it is only the Russian translation of the term champagne. I think Champagnskoye or something. I don't have a good pronunciation obviously in Russian, but that has been reserved for Russian sparkling wine. So I think your question was whether it. Sorry, what was your question again? Whether it comes to Canada. If this product, I don't even know if this product will be sold outside of Russia. If it were to come into Canada, maybe they don't even intend to sell these Champagnskoye wines, sparkling wines in Canada. But if they did, I think that it should be caught by the Border Protection Agency, and it is a translation of champagne. And as a protected GI and the Trademarks Act, it specifically holds that a translation is incorporated with spirits and wines, not so much for food and agroalimentary products. The protection afforded to a protected GI would only be one that is covered by translations that you file in your request. So those are a bit of particular things, nerdy things that we know in terms of trademark people, that when we file trademarks. But I hope I answered your question. I don't know enough about what's going on in Russia. All I know is what I've been told by colleagues of mine, that we have to be careful when we read the media in terms of, my understanding is these Champagnskoye wines in Russia are for the domestic market and are not necessarily directed to the rest of the world. Hope that answers the question.
Sure, and I can probably answer the next question. Does it normally have to be an official authority of a territory who can submit a request for GI protection? I assume a business entity or an individual does have the right to do so. It's a good question, and yes, as much as I'd love to be the owner of a registered GI, I probably can't. When you file a request, and Ekaterina mentioned it briefly, you need to a request for the protection of a GI. You need to explain who the responsible authority is going to be, and you have to explain a little bit how does that entity have the authority to register this GI. So typically, it's going to be a law in the local territory, for example, a law in France, a law in Italy, that gives to this entity the right to protect a certain GI in that territory and abroad. So, for example, that there's a law that grants the Comité Champagne the power to protect champagne in France and abroad.
So I think we received a question from a non-anonymous person, Paolo Veronesi in Italy, and I'll just read it for everybody's benefit. So hi, Paolo. The indirect relation between GI and a similar trademark Champagnerie case can be regarded as similar to the concept of evocation of the EU Court of Justice. See the very recent decision on the Champanillo case in the EU. In other terms, do we go beyond the LOC typical of the conflict between marks, or we remain within the trademark law system? In the EU, there's an evocation of a GI, even if there's not a risk of confusion or unfair competition. So that's a very good question. And what Paolo is referring to is a recent decision of the UUCJ, the European, in the Champanillo matter. My understanding is the Champanillo was the trademark. It was, I think, a restaurant or bar, similar to our case of the Champagnerie, which is why we included it. And so in that case, just to let everybody else know what happened in the EU, I think the same client, the CDC, filed an opposition against the use of the name Champanillo to designate tapas bars. And the EUCJ decided that the regulation that protects PDOs applies both to uses for goods and services. So the answer to your question, Paolo, which is a complicated one, is simply, do we go? I think it's going to be determined on a case-by-case basis. I cannot tell you that a protected GI covers more than necessarily what it's covered for. I think it applies. I think the law says that it's covered. It covers, the wine, the food, the whatever. But again, in terms of, you would have to apply unfair competition. I think you would have to show the court and show the opposition board that the use of the protected GI, in the context of the services, just like we had in the Champagnerie file, how that would be problematic. And we often use the notions of either unfair competition, but also clearly descriptive, deceptive. Is a trademark? A trademark to be registered in Canada cannot be clearly descriptive. It cannot be deceptively misdescriptive. And I think there has to be some kind of relation to the wine and to, for example, in the champagne, like the cups of wines that people use in their thing. So I hope that answers your question, my friend. Let's look. Did you see another one while I was speaking?
Sure. I'm going to try to answer a question from William Biribe. Hi, Will. How do you foresee the impact of the latest traceability technology and systems available to consumers on the enforcement of GIs? A difficult question. So it's important to keep in mind, and I think that's something that we tried to convey with this presentation, is that sometimes it's also a question of perception. So as much as it would be great for consumers to be able to quickly be able to know that this bottle of champagne actually comes from Champagne or not, sometimes it's not sufficient. And even if you have an American champagne, then you can see quickly that does not come from the French region of Champagne. It's not sufficient. So it's also a question of perception. And even if it's consumers can know where a product comes from, if it could be problematic regardless of this. I don't know if you have anything to add regarding this question, Ekaterina.
It's a really good question. I don't have anything else to add on that. The only thing that I would say is I don't think it would change. It wouldn't change the way we address whether we would action something or not with an opposition or a federal court lawsuit. I think it would be a good, possibly a defense for a defendant who says, well, listen, my product is not. But the reality is, I don't know if everybody has those little traceability apps and stuff to be able to say where it comes from and stuff. And it's really the consumer. It's always the consumer. We always think, are consumers likely to be confused? Is the applicant seeking a monopoly or an exclusive use to a product, to a trademark that would somehow take away the fact that a certain expression, a certain term is a protected GI and really should benefit from the shared goodwill of other parties. So
I think you're right. And what we should underline is that consumers shouldn't have to use, traceability systems and traceability technology to know where a product comes from. If champagne is on a bottle of sparkling wine, if cognac is on a bottle of brandy, if piment d'Espelette is used in association with a product, you should be able just with that to know where the product comes from and to know what the quality of that product. So it's important to keep this in mind, and also to keep in mind that geographical indications does not just protect. It's not just a question of a region. So a product does not only benefit from the protected geographical indication champagne if it comes from Champagne. It's also a question of how it's made and has to be produced in a certain way, that the grapes have to be grown in a certain way. So I think that the traceability technology and systems in question would have to be very, very, very developed, well developed to answer all of these questions.
There's another question we got. There are countries with GIs for non-agricultural products. On what law could these countries base protection in Canada? And so what I would answer is, for now, given that Canada's Trademarks Act just provides for these 4 categories of protection, I think you would have to base yourself on the common law, the unfair competition, the claims, passing off. You would have to establish, and that's the case throughout Canada, even though we have a civil and common law system, civil being Quebec system and common law, the same laws with regards to common law rights apply. And so you would have to base yourself on the common law with regards to, and those provisions of the Trademarks Act that talk about, that Olivier covered in the early presentation, in terms of proving your goodwill, proving that there's goodwill in this name with regards to this type of product, that the reputation spans Canada. Canadian consumers know these products to be, know this term that is a geographical term that relates to, that product. And the 3 elements, of course, of the passing off claim would be, you have to prove your goodwill, you would have to prove your misrepresentation, and you would have to prove damages. So those are the 3 things, and that's why I think there's a benefit to having a protected GI. And I guess you would have to, try to lobby to, the government to expand the protection to other things. And it's a very interesting point. I hope I answered that question.
It is interesting. It's definitely something that we're going to keep an eye on in the future. I assume that the question refers to artisan products such as like Limoges porcelain and stuff like that. So yeah, it's very interesting, and I assume we're going to see changes in the law, if not in the near future, in at least a couple of years.
Just trying to see if there's any other questions that we have received which we have not answered. Okay, so does it normally have to be?
It's
Okay.
1 o'clock, we're gonna have.
Oh, it's done. Actually, okay. So I think we've answered a number of questions. It is 1 o'clock, so I just wanted to say thank you to everyone for having attended. For those 3 or 4 questions that I see that we have not answered, we will send you an email, follow through. Again, I wanted to send my very best to everyone all over the world, and thank you so much for attending. It's been a pleasure for us. Thank you. Take care, everybody. Be safe.